Hello everyone, this is just a short video in our second module, our second week, where we are going to briefly touch on history of special education. Special education's history is very interesting because when we usually think about history, we are thinking about hundreds of years or thousands of years, or depending on what we're talking about, millions of years. But special education as we know it has really only existed for maybe about 50 years at this point, maybe 55 years. So it's a very young field, and in that short amount of time, we have learned so many things, partly because of the use of technology that we just didn't even have 50 years ago, right? Or even 35 years ago. So we've learned a lot. We've come a very long way in a very short amount of time. So there's many things actually in that brief history we could talk about in special education, but for the purposes of this course being about collaboration and leadership and important concepts related to equity, inclusion, diversity, and differences and belonging, we're actually going to focus in on a very specific topic that actually kind of helped to create and drive the history of special education, which is litigation, which we'll define in just a second if you're not familiar with the term, which actually led to legislation, another word for laws, which is what led to us being legally obligated in this country to provide special education services to students that are identified with disabilities. That is somewhat unique to this country. Not all countries require special education services to be provided to people with disabilities through schools, and we do, and that comes from a history of litigation. So let's talk about what litigation is. Litigation, for a couple of formal definitions for you, are legal proceedings or a contest authorized by law in a court of justice for the purpose of enforcing a right. But the shortest, most direct way that you probably are more familiar with litigation is a court case. The idea of somebody, if I use another word, sues somebody else because they believe one of their rights or a right was violated, and they get lawyers involved to challenge forcing a right that they believed was violated, or something that they're trying to potentially obtain or change about a way that they were treated, right? So a court case, and in this case, in special education, in our brief history, we have kind of a pattern where litigation or court cases were filed for two primary reasons. One, because special education services were not being provided to students whose parents believed that they required or needed them in order to be successful and become successful humans in our society and learn social skills and academics and behaviors and things like that. The second reason is because students were being assigned to special education and being given special education services when their parents believed they did not require special education services and they did not have a disability. Either way, the overarching theme here is that students are not receiving what they need to be successful, and parents are the ones who are identifying that they know their child and something about how their child is being treated or labeled is not correct, and therefore they believe that there was a right violation there that needed to be challenged in a court of law. So let's go back two times in a form of miniature time travel to, first we'll go 100 years ago to some litigation or a court case. And then we'll go 50 years ago in order to see some of the progress that we've made. And then you will get the opportunity to investigate court cases yourself to see what you find in terms of the history of court cases and litigation and parental involvement in special education as a way to understand not only how far we've come, but also the impact of our beliefs or understanding of things like diversity and differences and disability and how we serve those things and the very real impacts that can have on a student's life trajectory. So these are two very real court cases, and they are very interesting to think about. So let's go back 100 years. This is the last name Beatty versus the Board of Education in 1919. So roughly 100 years ago. And in this case, it happens to be in the Midwest in the state of Wisconsin. And this is a direct quote from the hearings. The teacher said this about the student that this case is about, the last name being Beatty. His physical condition and ailment produces a depressing and nauseating effect upon the teacher and school children. He takes up an undue proportion of the teacher's time and attention, distracts attention of other pupils, and interferes generally with discipline and progress of the school. I'll pause for a second for you to just think in your mind, do you have anything that you think about in terms of what disability this might be? There's no reason to think anything, but just get your thinking about this and what the teacher was saying and wonder what disability or need might the student actually have. Well, in this case, this is the story of a 13-year-old boy who had cerebral palsy, so a physical disability where the brain signals are not correctly received by parts of the body, as a brief way to describe what that is. So in this case, this 13-year-old boy, which means he was in his neighborhood community public school up until the age of 13 with cerebral palsy, had average intelligence and was doing fine in school, but increasingly was drooling and having speech problems that were directly related to his disability of cerebral palsy. And the teacher didn't want him in the classroom anymore and had, in fact, removed the child from the classroom and said he cannot attend. And so the school board agreed with the teacher and recommended placement for this young man in a school for children who were deaf because it was the only different type of school in the region or in the area. Now, when you think about this, this should really make you think, this is a student who can hear and is doing fine in school, but is drooling and having speech problems, has cerebral palsy, and will eventually be in a wheelchair. Is a school for children who are deaf, who are likely learning sign language or other types of communication and appropriate placement? Absolutely not. Well, he refused this placement and was rightfully supported by his parents, who said this is inappropriate. He is no longer with his friends. He is no longer in our community. We don't agree with this placement at all based on his specific needs, and they took it to court. There was a court case. The municipal court, in this case it's Antigo, Wisconsin, ruled in favor initially of reinstating the boy in the public school, but the teachers in the school and administration were actually somewhat outraged, and so the decision was overruled by the Wisconsin Supreme Court, and he was not allowed to return to his neighborhood public school at the time. So this illustrates the idea that we were aware that there were maybe differences 100 years ago, but the teacher had the power to say, the fact that this young boy, this 13-year-old, was different in some way because of drooling and speech problems meant that he shouldn't be in the classroom, and that was upheld not only by the Supreme Court of the state, but by the school itself saying this difference requires him to go to a different school altogether is not something we would do today, right? So that already shows how far we've come, but also the power that a teacher's perspective can have on the trajectory of the student's learning. So let's jump forward to 1970, so about 50 years ago. This is also an interesting case. This is Diana versus the State Board of Education in the state of California. So in 1970, Diana was at the time described as a Mexican-American student in the Soledad School District in California. And she was in a neighborhood where there was a lot of Spanish spoken, and her primary language, her language of origin was Spanish, and she spoke that at home with her parents, and she was experiencing academic difficulties because she was technically, as we would think about it today, a multilingual or English language learning student, which of course then she's having some difficulties processing and translating a new language that she's hearing in school, or learning to read and write in a language that's not her primary language. So to us today, that makes sense. But at the time in 1970, that difficulty she was experiencing academically meant she was given an IQ test in English, and so she performed poorly on that test, and she was placed into a special education classroom. Now, at the time, the label was closely aligned with what we used to call, mental retardation or something like that, that we now know as an intellectual disability, and that's the preferred term. So if you were to research this, you would see some of those terms we no longer use, which also shows some of our progress and changes in a short amount of time in special education. So she was removed again from her peers to a fully special education classroom for students with pretty extreme intellectual disabilities. And at the same time, this was actually happening to 8 other Spanish-speaking students from her community. So those parents essentially got together and had some conversations and said, why are our children being placed into classrooms with students who have pretty extreme intellectual disabilities and deficits in academic functioning when they're fine, they are strong students? And so ultimately it was decided that giving them an IQ test in Spanish to see if it was true, after they challenged this and went to court. So they were given an IQ test in Spanish and saw a jump of 15 plus points, so that they were in an average or typical expected range for intellectual functioning, demonstrating that the use of an assessment that's not in somebody's preferred or primary language can directly impact how they perform, of course, on that assessment, right? And so then our instructional placement and decisions based on biased assessments can also have a very real direct impact on students and their placement and their performance in school. So what these and other cases show us is that in the history of special education, we have documented understanding that our lack of understanding of differences and how they show up in our schools can directly impact students through the easiest way to think about it is misidentification. And so students who don't require special education services might be receiving special education services or specific types of special education services that are not appropriate for them because we are biased in our viewpoint or expectations, or we are inadvertently using biased assessments. So the historic use of English assessments with biased questions to specific types of learners or places or people means that we are more likely to misidentify somebody with a disability and provide them services that they don't need, which means that we might be missing out on providing services to students who actually need those, who have documented disabilities or undocumented disabilities, because we're already providing services to somebody who does not need them because we didn't challenge our assumptions or biases that may be there in the questions or assessments that we're using. It also shows us that parent and family involvement is actually what shaped special education. Without their involvement and their advocacy, it's pretty likely we would not have special education as we do today. So one of the reasons that this course not only considers these important topics and these terms, but also is talking about collaboration and parents as part of that, is because parents play an essential role and are an essential component of effective special education, and their knowledge of their community, their needs, their child can very much inform our understanding of that student's needs. So it's really important that parents are part of as a matter of fact, we are legally obligated to include parents in the process of special education. So I look forward to you investigating some court cases yourself this module, and making some connections to these terms and looking at collaboration from that viewpoint.